Hi, I'm Jordan Isringhouse, the Chief Legal Officer at Swift Law North. I'm here today with Aaron Swift, CEO at Swift Law North. And today we want to talk about some kind of interrelation between the FDCPA and the FCRA. And to begin with, Aaron, to kind of set the stage here, I know in some of our other conversations we were talking about the FDCPA, debt collection, and now you're mentioning credit reporting. What's the intersection? How do you tie them together? Where are we headed?
Great question. So the title of this quippy little lecture is called Pay Up or Else, or Pay Up or We Destroy Your Credit. And that is a common theme in the debt collection industry, is trying to use the leverage of threatening someone's good credit with bad credit or derogatory credit to get them to pay. So yes, we've been talking about the FDCPA so far, common violations in general, but now we want to really tie into what are the types of violations when a debt collector is violating the law, but it relates to credit reporting, which is a more narrow focus, but it happens a lot.
Okay, so to that point, what are some of the common credit reporting debt collection violations? Or maybe I'm saying that backwards, debt collection credit reporting violations.
Right.
What are those?
And actually, you could say both ways, because the tail can wag the dog either way. You could have a credit reporting problem that also has debt collection, or vice versa. But here we're going to specifically talk about debt collection violations that have some tangential relationship to a credit report or about credit reporting.
And so in that vein, I mean, what are some common ones? Are we talking about just, hey, I already paid this, it's showing up on here,
right?
I don't owe this debt.
Yeah.
What are some of those kind of categories that, like, as an affiliate, for example, I should be looking out for people coming to me saying these things? What are you thinking?
So great question. Assuming by that time you've learned from our other videos, other types of violations to ask a consumer about. Have you ever told a debt collector to stop calling and they kept calling you? Like, that's an FDCPA violation. But when we're talking about credit reporting, there absolutely are a myriad of ways that a debt collector can violate the FDCPA because of its credit reporting, or even lack thereof. So I'll give you one classic example is, I had a debt, I paid it off, but now there's a balance reporting. It's 1, 2, 3. You had a relationship or a debt, it was owed. You might have paid it in full. You might have settled it. You might have gotten some insurance proceeds that pay it, whatever. But if a balance should be zero because you no longer owe that debt, it must be credit reported as a $0 balance. But that often isn't the case. Like, for example, we have consumers who settle a debt, and the debt collector gets lazy. They got their money, and now they just cut and run. But what they don't do is go and update the credit reports to now reflect that settlement or a $0 balance. So that's one example of credit reporting that can be an FDCPA violation. Well, how is that? Well, because now they're trying to say you owe money that you don't. So that could and will be an FCRA potential case too. And there are videos later in the series to explain that. But just the fact that they are credit reporting, telling the world that you owe a debt that you don't owe, that's one classic example.
Well, that raises the point. Telling the world you owe a debt you don't owe, that triggers in my mind, everybody thinks of identity fraud and identity theft. And that's I think the height of someone saying I owe this and I didn't do it, I don't owe it. I mean, does that tie in? Absolutely.
So classic example or fact pattern, a consumer comes to one of us lawyers directly or one of our affiliate partners, our scholars, and they say, there's a debt on my credit report I don't recognize, or it's not mine, or they even know what happened. It's my ex-wife or my spouse or former partner who stole my identity, because that person has all your private information, probably your social security number, maybe your birth date. That's another classic example. So I didn't open up an account. Someone else opened up an account in my name. Let's say I lost my wallet. They were able to steal all my information. Well, if you just think about it, I don't owe that. So if that information is on my credit report, and we've told the collector and try to give them opportunities to recognize it's not mine, but they keep going down that path, keep credit reporting, keep debt collecting, that's a problem. So identity theft, fraud, just think about, for the consumers, for our affiliates, if the consumer doesn't owe it for any reason, whether it's paid off, settled, they didn't take out the account, they're a victim of fraud. Those can be examples of debt collection conduct that can lead to FDCPA violations from credit reporting review.
In terms of debt collection conduct, that was something that kind of sparked my mind there. One of the things I hear from people are, the debt collector called and said this and said that. And sometimes they think, can the debt collector even do that? I mean, does that play any role in it?
Great question. So assuming that you're on video 5 and you probably just watched video 4, under this specific series, you would have just heard about other common types of violations. And one of the things you cannot do, as I said, or we said in the previous video, is make a threat that you don't intend to follow up on, or just make a threat that you cannot make. One classic example that debt collectors do is they will threaten to negatively credit report a debt, but then they don't do so. And here's why they do that on two parts. Number one is it's a scary threat, right? So as all of our audience knows, your credit report, your credit score are so incredibly important. So just the mere threat that I'm going to negatively credit report if you don't pay has a lot of weight. And the other thing is it's expensive to credit report. So Experian, Equifax, TransUnion, they make their money not from us. We're basically the products for them. Their clients are Capital One, Bank of America.
Us as consumers, right?
Yes, exactly.
Okay.
Yes, us as consumers, we're the product. But they have to pay money for the privilege of reporting information to the big three. So if a debt collector wants to put that debt on your credit report, they have to pay. And some of them are cheap. So what they do is they just threaten to credit report against you. But that is something you cannot do. Generally speaking, under this law, the FDCPA, you cannot make threats that you don't intend to follow through. But in this specific purpose, it's done all the time. You cannot falsely threaten to ruin someone's credit, to hurt their credit, to report something if you don't actually intend to do so.
One thing that is on people's credit reports that is a big focus for people, I think, is that they believe, and rightfully so, that can hurt their credit report or just make it make them look less credit worthy, are hard pulls of their credit report and like who's accessing it, things like that. Right. I mean, what if that's on someone's credit report, and again, it's kind of like the same thing. I don't recognize this. I mean, is that another violation?
Yeah, it certainly could be. If I understand, you're kind of asking about the inquiry section.
Yeah.
So hard inquiries, soft inquiries, promotional account reviews. One of the other things we've already talked about during the series is credit reporting basics. How does it work? Who can do it? Who can't do it? And one of the hallmarks of that law is privacy. And so they have your social, they know everything you've taken out with debts. They sometimes know your medical history if you have medical debts. So this is information that's protected or should be protected heavily, which means that if someone wants to access your credit report or pull it, obtain it, kind of colloquial terms we talk, let's pull your credit report. But to do so, you have to have what's called a permissible purpose. And usually that's just in a contract. If I want to buy a car, I go to the dealership, I'm going to sign a contract that says you can pull my credit report. That is giving them permission to do so. Now, under the law, the FDCPA does give a debt collector the right to access someone's credit report for collection purposes. And that makes sense, right? You want to figure out, for the debt collector, does this person have money? How much are they putting out every month? Do I think they're going to have some extra money to pay this particular debt? But what they can't do is do a hard pull, like you just described. And a hard pull is actually an application for credit. That does hurt your score. The more hard pulls, the more applications for credit, your score goes down. So a debt collector should have no right to do a hard pull on a consumer, because I'm not trying to apply for debt with this debt collector. What they have the right to do is do a soft inquiry or an account review inquiry. And if they do the wrong one and it hurts the consumer, that's a problem.
Okay. So let's say a consumer comes to you with some of these kind of crossover areas of concern. So debt collection that's occurring that is showing essentially signs that it's on your credit report, or there's issues here. What does the consumer do?
Great question. So if you kind of harken back to video 3 of this series and the FDCPA video series, we talked about more of the FDCPAs of this law. And what I would say is, in this specific scenario, is follow those steps that we talked about. For consumers who may be watching this series, find a lawyer, talk to your affiliate partners, because you have protections. If you are one of our affiliate partners and a scholar and you work with consumers directly, ask them these types of questions. Did anything on your credit report? Hey, this debt collector you're talking to me about, have they ever threatened to do something? And if the answer is yes, like let's say, for example, just the classic one, there's a debt collector, I've already paid off this debt, they're reporting it on my credit. On one hand, what you're going to learn at the FCRA, the Fair Credit Reporting Act part, which are the next set of 10 videos, you're going to have some steps to do there. But because we're talking about the FDCPA, what's most important to know is you can stop that conduct. You can ask a debt collector to stop making threats to me. And if they've already broken the law, you have rights. Like we've talked about, you may be entitled to $1,000. You can get the conduct to stop. The debt might go away if it's not legitimate. It might come off your credit report. And best of all, there's usually no cost or no risk to the consumer for that. So they can get the problem fixed. These credit reporting related FDCPA violations will hold them accountable. And at the end of the day, fight back against these companies.
Well, thank you, Aaron. We appreciate it, and we think that that's a good combination between the FDCPA and the FCRA and how they intersect. So if you have any questions, reach out to Swift Law North, myself, or CEO Aaron Swift, and continue to enjoy these lectures in our series. And if you have any questions, please let us know. Thank you.
Thanks, Jordan.